and welcome to Season 2, Episode 6 of ARBinBRIEF. My name is Dara Sahab. I am a part of the team of ARBinBRIEF. I work with 𝗔𝗕𝗙𝗙𝗏𝗏𝗏 in Dubai, and I will have the pleasure of moderating today's episode. A few words about ARBinBRIEF. ARBinBRIEF offers a practical video guide on handpicked arbitration issues and showcases talented arbitrators. ARBinBRIEF is produced in collaboration with ARBitration Pledge and Delos Dispute Resolution, and Season 2 is sponsored by LALIV. Our discussion today on climate change issues associated with international arbitration features Annette Magnusson, who is the co-founder of Climate Change Council, a think and do tank committed to accelerating climate change solutions through law, based in Sweden and serving the planet. And we also have Sadaff Habib, who is the founder of Equanimity Arbitration and acts as independent arbitrator and counsel based in Dubai, UAE. We have seen the impact of climate change in almost every aspect of our lives, but have we considered its impact on us as arbitration practitioners? Today, we will discuss with our speakers the present and future of climate change disputes in international arbitration, and more importantly, how we can be more climate conscious as international arbitration practitioners. Let's start with you, Annette. As an international arbitration practitioner with a focus on climate change issues, how do you see issues associated with climate change cross over with international arbitration?
Thank you, Dara, and hello, everyone. And that is a very good question, and it's a question that we have been discussing more and more in recent years, not least since we set up Climate Change Council. I think it overlaps in many different ways. It's both in commercial arbitration, in investor-state arbitration, but also we see spillover effects from climate litigation into international arbitration. So looking, for example, at commercial arbitration, we are seeing a lot of societal transition and a lot of projects being motivated by the climate change crisis. And we do know that a number of these will, of course, end up in arbitration. And there it will require the expertise and an understanding of the climate change aspects of the project, for example, in an arbitration setting. We also see how the changing standards around certain regulations and how they are applied and how they are understood, how that is being shifting because of the climate change crisis, because of climate risks. That also plays into international arbitration. And one very concrete example is, of course, post-M&A disputes and climate risks in that context. If we move on to investor-state arbitration, we have seen and we will probably see more investor-state cases where they are either prompted by an action by the government, which is governed by or motivated by the government's ambitions to meet the Paris Agreement's targets. The fossil phase-out cases against the Netherlands is examples of that. And that is a very concrete example of how climate change is visible in investor-state arbitration. And we do not know the outcome of those cases yet. They are pending, but it's likely that we will see more investor-state cases in the crossover between climate law and international investment law. And finally, climate litigation. One of the outcomes of climate litigations, which is also increasing quite dramatically in the recent years, is that not only will perhaps regulations be differently understood, but it will also be changed and revised to some extent to meet the targets, for example, under the Paris Agreement. And as regulations are changed, of course, this could spill over also into commercial arbitration disputes. So there are many ways in which climate change has a crossover or lap over with climate change and international arbitration.
Thank you very much, Annette. And as a follow-up to that, Sadaff, how relevant do you think climate change issues are, and how likely are they to appear in international arbitration, given what Annette has mentioned with the Paris Agreement and probably the drive towards zero emission? If you can expand on that.
Sure. Thanks, Dara. So yeah, I mean, I would say it's not even just relevant. I would use the word urgent, because like what you hinted in the question, we have a deadline to achieve net zero emissions by 2050. I mean, 2050 is not far off. If you think about it, it's 27 years to get our shit together, basically. Pardon my French, but it's true, you know? It's like about time we do damage control. So yeah, I mean, with this sort of date looming, it's expected that the investment into clean energy is definitely going to increase. In fact, I was reading that it's expected to triple to about $4 trillion by 2030, and that's not a small figure. So when you think about that, and you think about the pumping of all this investment, and which will obviously give way to clean energy technologies and innovations. Now, obviously, that means that there will be more opportunities for new businesses to come up. Now, with new businesses, that will also increase the risk of disputes. So we have this sort of pattern that's coming along, and I'm saying that it will increase the risk of disputes because it is likely that these new projects will involve new innovations, new technologies, new infrastructure systems, which are likely to be put in place and are being put in place, and new collaborations between parties. Now, given the nature of all and the involvement of all these elements and the pace at which change is happening, I would say that international arbitration would appear to be the appropriate forum for these kind of disputes to be heard through. Now, international arbitration, by just even outside this topic, it is a frequent choice in cross-border transactions. We're not alien to that, especially where a party is a state or a state-owned entity. And even in emerging markets, such as the energy sector, it would be a popular choice as a dispute resolution forum. Now, it's also a mechanism of choice where confidentiality and privacy are important points for the parties to consider. And since we're talking about new technologies and new innovations, that would be something that the parties it would be at the forefront of their minds, I would think. And obviously there is just looking at arbitration, it is a neutral forum that allows parties to choose their arbitrators, which would be an added benefit to such disputes. And I think, yeah, just to conclude on that point, I would say international arbitration will also be attractive because it enables the cross-border recognition and enforcement of arbitral awards, which would assist this entire process. Yeah.
Yeah, and so Sadaff, you highlighted many of the advantages, we would say, of arbitration that could play into what we call a climate change dispute, one of which is confidentiality. Annette, what are your views on confidentiality in arbitration, especially when it comes to disputes relating to climate change?
No, it's absolutely right. Confidentiality is certainly one of the main reasons why commercial business choose arbitration. But I do think that in a climate change context, maybe as arbitration practitioners, we should revisit the issue of confidentiality, because we are, as has been pointed out, we have very short of time. And as many of these projects are involving new partnerships, new innovations, new technologies, and of course, we want to learn faster, and maybe we need even our competitors to learn from these mistakes, so we all can work together towards reaching the net zero by 2050. So maybe we should be more open about the lessons learned from this dispute, and maybe have a different view on confidentiality and be prepared to share what we have learned. What was the problem? Was it the technology? Was it the partner? Was it the policy? Was it the financing? And find a way to make 1 + 1 = 3 in this context. So I call this climate related dispute intelligence. We should find an organized way of sharing that for all actors involved in this space.
Thank you very much, Annette. And I agree, this will be an interesting debate, I'll say, of confidentiality versus what we will call the public policy, concerns or interests, really, when it comes to climate change. Now we move on to a different but related topic, also to you, Annette. I've heard you use the term climate conscious lawyering before. Now, what does this term entail, particularly for arbitration practitioners, and what does it mean to you And how do you think arbitration practitioners can integrate these climate conscious practices in arbitrations?
To me, being a climate conscious lawyer means that you always ask yourself the question, how does this matter fit into the bigger picture of societal transition to meet climate change targets? And it may not be that climate change is mentioned specifically in the documents that are presented before you or what you hear from your clients, but you should ask yourself, what does the bigger picture look like? And you should introduce that perspective into your conversations with your clients. So that could be both substantive issues, but it could also be strategic issues. So it's really about always watching or assessing the matter through that particular lens. And just one concrete example, for example, if you are advising on the choice of dispute resolution methods, maybe since if it's a project relating to, for example, new technology that we talked about before, maybe you should have mediation higher up on your list of recommendations rather than a full-fledged arbitration, because it's usually faster and we need to resolve disputes faster. So that would be a very concrete example of how you infuse the climate change mindset into your strategic advice to your clients. So it's really something that should really go through everything that all the conversations that you're having.
Yeah, and Sadaff, what are some ways you think that parties or stakeholders in international arbitration proceedings can integrate such climate conscious practices, for example, from an arbitrator perspective, when it comes to, drafting procedural orders or, setting the tone to the proceeding, let's say?
I would say the first thing that comes to mind is to revisit your case management techniques, because it's not necessary. I mean, look at the bigger picture, but also look at what issues are involved in the dispute, because it could be that you could look at, for example, bifurcating proceedings, or you could consider issuing partial awards in different issues, or even depending on how, the technical issues or the special climate change related issues, whatever it is, you could even decide that one of those issues could be dealt with on a documents only basis. And instead of having a full-fledged hearing and, the whole, shenanigan, just try to manage your cases better in a way that is climate conscious. Yeah.
And Annette, just one more follow-up question. What are your thoughts about making this more into creating a more robust framework for arbitration practitioners to adopt these practices, such as, we have the Green Arbitration Pledge, for example, but how do we really, what are your thoughts on how to take it to the next level, for example?
No, the Green Pledge is brilliant, and I do think that the pandemic really demonstrated how doable it is to apply the methods that are foreseen in the pledge. And as Sadaff points out, you can sort of bring this up in your case management, for example, in your first procedural meeting with the parties to adhere to the pledge. But I think the next step would be to see more and more of these ambitions being embedded in arbitral institutional rules. We have seen some examples of how the possibility to virtual filing is recognized, how you can have your hearings virtually, or not necessarily at the place of arbitration is recognized, so sort of creating that flexibility. We have seen arbitral institutional rules recognizing the need to be environmentally conscious, which is brilliant. So I think we're beginning to see small signs, and I think that's where the next level of development will be, when you call it like robust rules, right? Yes. If you put it in the arbitral rules, then it gains a different force naturally.
Yes. And speaking of arbitral institutions, taking the Delos rules as an example here, do you find that the Delos arbitration rules include some of these climate conscious practices, or embrace them within their rules, let's say?
Well, yes, I think electronic filing is certainly a recognition of that, and the flexibility on sort of where you have your hearing. And it's a good starting point. And I think, but I think much more can be done clearly. And for those measures that I just mentioned, sort of to to recognize even more clearly, for example, that you could have virtual hearings. I know there's some jurisdictions where that this has been debated. We've put away all that out. And again, maybe we will have institutions going forward that will be very bold and brave, and they will actually even have a model arbitration clause for climate-related dispute intelligence, and you know, where parties can agree beforehand that should we end up in a dispute where this could be relevant, we will do our best utmost to share for the greater good. That would be interesting. That I've thrown that idea out before. So I haven't seen any institution taking up that challenge yet, but I hope there are some smart minds sitting out there working on drafting.
We sure can hope that. Well, thank you so much, Annette and Sadaff, for a very insightful and intriguing discussion. We also thank our partner organizations, Delos and ARBinBRIEF Pledge. Delos Dispute Resolution is an independent arbitral institution established in 2014. The ARBinBRIEF Pledge establishes concrete and actionable steps to increase the number of women appointed as arbitrators with the ultimate goal of full parity. The sponsor for our second season is 𝗔𝗕𝗓, an international law firm with offices in Geneva, Zurich, and London, renowned for its expertise and experience in dispute resolution. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel in YouTube. We would love to hear your comments and feedback, and you can register for our next episode on www.arbinbrief.com. We look forward to seeing you there.